Hello everyone, this is Dr.P.Syamala from the Department of MBA International Business, Acharya Nagarjuna University. And now today we are going to a new session regarding business legislation. So, in business legislation, we will see the introduction part of business legislation or else business law or else mercantile law. Okay, so first of all we will see about what is law and then we'll further go and see business law. Okay, so if we see about what is a law, what are the important characteristic features of law, okay, and then we will see what is the business law and what are the sources of law, what are the branches of law. Okay, so all this comes under the introduction of law and both business law. Now coming to the meaning and nature of law. So what is the meaning and what is the nature of law? So if we see the word law means it is used in many senses. Okay, so here many senses means if we take in widest sense, okay, law means any rule of conduct, standard or pattern to which actions are required to conform. If not confirmed, sanctions are imposed. Okay, so this is about the widest meaning of law. Means every person or else every citizen of a particular country has to follow its or else the country's rules and regulations. Okay, the rule of conduct will be there, standards will be there, the patterns will be there. Okay, so that the persons they have to follow the rules and regulations. Okay, so that is the widest sense of law. Means under this we will see the basically the rule of conduct means how to behave. Okay, so or else the standards or else the patterns to be followed, the standard rules, okay, the standard regulations that has to be followed. So all these comes under the widest sense of the law. Okay, and where if the actions should be according to that law only, the people, the persons should follow the law. They should act according to the law, that which is nothing but the rule of conduct, okay, standard or the pattern. If not, if at all the persons have not followed those rules means, okay, sanctions are imposed on those persons. So what are those sanctions means? Sanctions are nothing but the force that is used upon them in order to follow the rules or else in order to follow the law. Okay, so that is the widest sense of law. And if we see about the law of state, okay, if we see the law of state, S-T-A-T-E, this is okay. So widest sense regarding the law means it is related to the rule of conduct, standard or pattern if we speak about law. But if we speak about law regarding the state, okay, means law in a special and strict sense. Okay, this law of state can be studied. Okay, or else the law of a state, we use the term law in a special and strict sense. Okay, means special and strict sense, they include that these are the rules which are recognized and acted on by courts of justice. Okay, so these rules, widest sense law means these may be regarding to the rule of conduct, standard or pattern where there may be no court of justice, but there may be ethical laws, okay, moral laws. So according to that, here people will act. But if we speak about the law of state means, definitely it involves the strict sense, special and strict sense. Special and strict sense means these rules are recognized, okay, and acted on by court of justice. Means if at all the persons, they do not abide the rules, they do not abide the law, means definitely, okay, they will be in court of justice. They have to face the court of justice. Okay, so that is the difference between the state law, okay, law of state, and this uh, the law. Okay, so here finally we can say that law may be defined as rule of conduct of persons. So how to behave, okay, what is the pattern that to be followed regarding the laws, okay, so that is the rule of conduct of persons. Here persons means both natural and artificial, anything will be uh, will be taken and imposed upon and enforced among the members of a given state. Okay, so rule of conduct is a law. Okay, so this law is imposed upon and also at the same time enforced. Without imposing or else without enacting and without enforcing it, we may not there will be not any meaning for creating a law. So therefore rule means it is defined as a rule of conduct where it is imposed and also enforced among the members of a given state. Okay, so this is a law. So finally we can say that law means it is a rule of conduct of persons where it is imposed upon and enforced among the members of a given state. Right? Here we can say that the rules are enacted, okay, a formal enactment or from customs which a particular state or a community recognizes as binding on its subjects or members. We can say like that law. Okay, means it is a formal enactment, okay, body of rules, whether proceedings from formal enactment through enactment, okay, or else from customs. Customs are nothing but from previous laws we will take those laws, okay, so and we will follow those previous laws as a custom. The laws will be followed as a custom. So here if they may be proceedings from the state or else they may be we may follow the laws through customs also. Okay, and coming to the important elements or else the characteristic features of law. So what are those? If we see first one is law is a body of rules. Okay, this is the first feature of law. So law is a body of rules. Rules means here these rules prescribe, as I said before, rule means law means it is a rule of conduct. So here law is a body of rules which means or else which prescribes the conduct, the standard or else the pattern to which actions of the persons in the state are required to conform. Conform is nothing but they have to act according to the law. If at all they have not acted according to the law means sanctions will be imposed on them. Sanctions are nothing but the punishments or else a force will be used on them. Right? So this is law is a body of rules. Okay. So however all rules of conduct do not become law in the strict sense. Okay. We resort to various kinds of rules to guide our lives. Okay, so for example our conduct may be guided by a rule like do not be disrespectful to elders or women. So this is a law. So law in the sense this is related to the moral law. Okay, for this there will not be any punishment, but these are regarded as ethical or moral rules. Okay, for this there will not be any imprisonment or else any fine is imposed upon a person who have a disrespect towards elders or women. Okay, so here as I said before, all rules of conduct do not become law in the strict sense. Means in such cases we may not consider the law in a strict sense. Okay, so on the other hand, if a person does not observe the law of the land, okay, then legal actions will be taken on that person who is not acting according to the law. Like actions will be taken, like such as imprisonment or fine, okay, etc. It will be imposed upon him. Okay, so however, law and morals are closely related, though they do not by any means coincide. We all know they will not coincide. Morals are different and the rules and or else the laws are different. Okay, but even though, okay, we will see both of them. So thus we may state that the state makes or authorizes to make or recognizes or sanctions rules which are called the law. Okay, so definitely state makes or else state authorizes to make or else to enact the laws, recognizes the laws, and also at the same time it imposes sanctions on those rules also. Okay, why? Because if at all the persons who will not act according to the laws, means sanctions will be imposed on those persons, which are nothing but the imprisonment or fine regarding the state laws. Okay, so here the law means it is embodying various rules. It has number of sources. Where do we will take these laws? From where we will enact these laws? From where we will take those laws? Means from number of sources laws are being taken. Okay, like such as customs, legislation, precedents, etc. Okay, customs are nothing but in previous years, okay, long back years, custom will be followed depending upon the religions or else depending upon the nationality, depending upon their cultural aspects. Some customs will be followed. Okay, so according to that also laws may be enacted. Okay, or else through legislation. We all know through legislation, through enacting bills from the parliament. Okay, so the rules will be enacted. And precedents means taking previous taking into consideration the previous decisions will be taken into consideration, and according to that laws will be enacted. Okay, for example, in any case certain judgments will be given, so depending upon those judgments certain laws will be framed. Okay, so there will be like that, different sources will be there to enact these laws. Okay, so law means it is a body of rules, okay, which prescribes the conduct, which prescribes the standard, which prescribes the pattern to which actions of persons in the state are required to conform. Okay, now coming to second one, law is for the guidance or conduct of persons. Okay, so here we may say that both human and artificial. Okay, in previous here in this definition also we have seen. So law may be defined as rule of conduct of persons, both natural and artificial, whatever it may be. Okay, so law is for the guiding of a person, how to behave. He has to behave according to the law only. He may not go beyond the laws. If at all, if he act beyond the laws means definitely he is going to be punished, okay, through imprisonment or else by through fine, okay. So law is for the guidance or conduct of persons. The law is not made just for the sake of making it. The rules embodied in the law are made so as to ensure that actions of the persons in the society conform to some predetermined standards or patterns, okay. So law is not made just like that, okay. Definitely those are embodied in a law, okay. And actions of persons, okay, the actions of the persons, they should act according to the laws only, means predetermined standards. They have to act according to the predetermined standards, conduct, pattern, okay. So this is necessary so as to ensure continuance of the society. So we can say that rules are therefore drawn up to ensure that members of the society may live and work together in an orderly manner, okay. If at all there are no laws means, okay, we may not see a good environment in the society. If at all there are rules only, we can ensure that members of the society may live and work together in an orderly manner. So therefore, if the rules are embodied in the law are broken, compulsion is used to enforce obedience and certain consequences ensue. Means if at all the persons do not conform or else do not act according to the law, definitely compulsion, coercion, force is used to enforce obedience to law, okay, and certain consequences will be also to be faced by that particular person, okay. So law means definitely it will guide the person, okay. Now third one is law is imposed, okay. Law is imposed means on whom the law will be imposed, on the members to bring about an order, on the people in a society to bring about an order in the group, okay. Why means to enable, to prosper, to continue. So that is why law is imposed, okay, to bring out an order in the society, in the group, in the people. So it is not something which may or may not be obeyed at the sweet will of the members of the society, okay. If you cannot impose a rule, it is better not to have it. So law is imposed, definitely law is imposed. If we enact a law and if we do not impose means, so what is the use of law? So therefore a law is enacted means, okay, you have to impose that law, okay. If you cannot impose means, it is better to not have a law. So thus law is made obligatory on the members of the society. Obligatory, they have to obey, okay. It is their responsibility on the members of the society to act according to the law. So law is imposed. Another feature is law is not only enacted, not only enforced, it is imposed also. And law is enforced by the executive, okay. So unless law is enforced, it ceases to be a law, and those persons subject to it will regard it as dead. Means not only enacting a law, but we have to enforce it, okay. We have to bring out it, okay. So if at all, if the law is only just framed but it is not enforced into an act means, okay, so it is of no use. So for example, if A steals B's bicycle, he may be prosecuted by a court and may be punished, okay. Also, the court may order the restitution of the bicycle to its rightful owner, to give it to the rightful owner, that is nothing but A. Okay. So here B, if the government passes many laws but does not attempt to enforce them. Okay, many laws were made regarding this theft aspect. Okay, but no attempt to enforce them, then the citizens lose their respect for government and law, and society is greatly weakened. Okay, so therefore the force used is known as sanction, which the state administers to secure obedience to its laws. Okay, so here we may say that enforcement means if a certain law is enacted, means it should be enforced through certain sanctions. Sanctions are nothing but if anybody goes beyond that law, means definitely, okay, the consequence will be punishment. Okay, either anything, imprisonment, or else fine, or else any other thing. It should ensure the observance of law. So that is known as the enforcement. Law is enforced. Okay, so here another important feature is the state. Okay, so a state is a territorial division with people therein subject to a uniform system of law administered by some authority of the state. Okay, so the state is nothing but the territorial division. Any state, any state having a people, a population. Okay, a territorial division with people. Okay, where a uniform system of law is administered by some authority of the state. So, thus law presupposes a state. Okay, means each state will have, here state means we can consider as a country. Okay, so each country may have its own laws. Okay, Indian laws differ from US laws. US laws differ from Chinese laws. Likewise, so each country have their own laws. Okay, so that is a state. The state means the law presupposes a state. Okay, and it is administered by some authority of the state. And now coming to another feature, content of law. So the law is a living thing and changes throughout the course of history. Okay, depending upon the requirements, depending upon the cases. Okay, it changes over a period of time, and law responds to public opinion and changes accordingly. So these changes will be made depending upon the public opinion. Okay, now law can never be static. Okay, so it is a flexible thing. Therefore, amendments are made in different laws from time to time. Okay, so content of law means definitely it is flexible. It depends upon the opinion, public opinion. So according to that changes only public opinion. Here amendments are also made in different laws from time to time periodically. Okay, so for example, if we see means the monopolistic and restrictive trade practices. Okay, MRTP Act, we will say 1969. So it has been subjected to many amendments since its inception in 1969. Okay, so several amendments have been taken in this particular MRTP Act 1969. Okay, so why? Because it depends upon the requirement, it depends upon the certain situations, it depends upon the opinion of the public. It changes according to the requirement of the public opinion, response of the public opinion, and changes can be made in those laws. Okay, by amendments. Now another one is two basic ideas involved in the law. So what are those two basic laws? Okay, one is to maintain some form of social order in a group. Okay, so that is the first basic idea which is involved in law. Means to maintain a social order should be there within a society. A social order should be there within a group. Okay, and what is the second basic idea means to compel members of the group to be within that order. Okay, so a social order should be there, and second one is compulsion, force should be there on the members of the group. Why? Because to follow that order, to follow that within that order. Okay, so these basic ideas underlie formulation of any rules for the members of a group. So a group is created because first there is a social instinct in the people to live together. So that is why a group is created. Okay, we all know about a group. Group is nothing but um, a group is made with a group of individuals involved in a group. Okay, so the main instinct of forming a group, or else the main social instinct in the people, is to live together. Okay, and secondly, it helps them in self preservation. Why groups will be formed means in order to satisfy their needs through, or else with the help of the groups. So it is nothing but self preservation. And rules are made by members of the group so that the group doesn't wither away. So in groups also we will see the rules. Okay, so why rules are framed in the groups means the group will not be disturbed if at all there is no prescribed rules and regulations. Okay, so that is why in order to see uniformity, in order to see order in the group, okay, rules are made in the members, by the members of the group. So as members are interested in continuing the group, penalty is also provided for the non-observance of the rules. This is nothing but the punishment if at all they are not if the members of the group doesn't act according to the group. Okay, so another one is last thing, law is made to serve some purpose which may be social, economic or political. Okay, the basic purpose of the law means to serve some purpose. Okay, so some examples of law in the widest sense of the term means moral rules or etiquettes. Okay, the non-observance of which may lead to public ridicule. And second one is law of land. Okay, first one, some examples of law means one is in order to serve the moral rules. Second one is law of land means the non-observance of which may lead to arrest, imprisonment, fines, etc. So for that purpose law is made. Means it says the people, it says the members of the society that if at all they are not in observance of the law means it will lead to the punishment. Okay, imprisonment, fines, etc. So another purpose is it is a law of land. First one is moral rules. Means moral rules are nothing but if at all any non-observance of the public, it may non-observance of the law may lead to public disturbance. Okay, and the third aspect under this is third purpose may rules of international law, the non-observance of which may lead to social boycott, trade sanctions, cold war, okay, proxy war, etc. Means this is the third purpose we may say regarding the law. Okay, so that is why social, economic, political. Under social we may see the moral rules. Under economic wise if we see law of land. Okay, and political wise rules of international law means, so international law means the law which is created for foreign country and our home country. So laws will be made. Why? Because in order to have a good trade between the two countries. Okay, so not only trade, in other aspects also, politically, legally, economically. Okay, so in all aspects there will be an international laws between the countries. Okay, so therefore if at all there is a non-observance of these laws means, okay, we have to know other countries rules and regulations also. Okay, if at all if we want to have a company in other foreign country means according to their rules and regulations we have to form our company. Okay, so therefore there should be an observance of law of other country also, which is nothing but international laws. If at all there is no observance of law means, okay, international law means it may lead to social boycott, means our country may be boycotted, okay, or else trade sanctions will be imposed. Sanctions are nothing but there will not be any trade, more rules and regulations will be imposed. Okay, those are the trade sanctions, and there will be a there may be cold war, proxy war, etc. Okay, so the purpose is to serve some purpose. The law is made to serve some purpose. Okay, so that purpose may be either social purpose, economic purpose, or political purpose. Okay, so these are the features regarding the law. And being a law student, okay, or else being studying this business legislation subject, the first thing, okay, that we should know is that ignorantia juris non excusal means ignorance of law is no excuse. Okay, what does ignorance of law is no excuse means? Every member of the society is expected that his actions conform to set pattern or standard as reflected in legal rules. Means every member of the society, he should be in observance of the laws. Okay, he should act according to the laws. He should act according to the set pattern, predetermined patterns of laws, standards of laws, okay, which are reflected in the legal rules. Okay, so he should, for this purpose, he is presumed to know the legal rules. He cannot take the plea that he did not know them. So I don't know that particular rule, and for that there will be no execution under the eyes of law. Okay, we may say that a normal person may not be subject expert in all the rules and regulations of a country. Okay, so but no doubt in practice we know that he has to learn and understand all the laws of the land which he is residing. Okay, or else he can obtain expert guidance from those who possess legal knowledge. For example, if a person want to have a company, means definitely even though he doesn't have all the comprehensive knowledge regarding the formation of a company, he should go for a expert guidance, okay, regarding to have a company. Okay, or else any other thing, not only having a company. So for that purpose he has to go for a subject expert regarding that particular aspect, and he should possess a legal knowledge. Okay, so thus he has access to books also on law, and to those persons who are experts in legal matters. Okay, so finally what we can say means ignorance of law is no excuse. Okay, so members of the society, they have to know about the law. There should not be non-observance of law. Okay, so ignorance of law is not a good excuse. And coming to another aspect, classification of law or else branches of law. So what are those branches of law? Okay, if we see means public law, private law. Okay, second one is criminal law, civil law. Third one, substantive law and procedural law, international law and municipal law, public international law and private international law. So these are the branches of law. Okay, if we see first aspect, public law and private law. So what is the public law and what is the private law? So public law means it is a branch of law which determines and which regulates the organization and function or its functioning of states. Here states means nothing but the countries. Okay, so here The public law means it is also a branch of law. What does it do? Means it determines the laws. It regulates the organizations and functioning of the states. How to function, okay? How to regulate, how to determine the laws, okay? So, and also it regulates the relation of the state with its subjects, means uh, how the relation of the country with other aspects, okay, in the state or else in the country will be also stated in the laws, okay. So under public law it includes constitutional law, administrative law, criminal law, municipal law, international law, okay. So all can be studied under this public law, okay. But criminal law is enforced on behalf of or in the name of the state only, okay. So this is about the public law, means public law is nothing but which is determined, which is regulated, which regulates the organization and functioning of the state or country, anything, okay, state or country. Now coming to private law. So what does private law means? So as public law is related to country, private law is related to the regulations on citizens, okay, relations of citizens about their rights and duties, okay. Private law speaks about the rights and duties of individuals, how to behave, the conduct of the persons, their relations, okay, relations of citizens with another's, okay, but not of public importance. Means public importance means it comes under the public law, but here it is related to private, means within the individuals or else with individuals with other individuals or companies, like that, okay. So private law is of rights and duties of individuals to each other, okay. Now coming to under private law. So what may come under private law means it includes law of contract, law of tort, law of property, law of succession, family laws, okay. So all laws can be considered as a private law. So this private law can be considered as a civil law, okay. So in case of private law, the role of the state is merely to recognize and enforce the relevant law. So that is the case in the state. The role of the state is that, means it has to recognize and enforce the relevant law to what aspect it comes under. As I said before, under private law it includes many aspects like law of contract, law of property, law of succession, family laws, law of tort, okay. So under which aspect it will come? It will see the state, okay. So these are the private laws. So purely public law is concerned with the determination and regulation of the state, functioning of the state, but private law is related to the citizens, okay, the rights and duties of the citizens. And coming to second one, criminal and civil law. So what does criminal law and what is civil law? So criminal law is the part of the law which characterizes certain kinds of wrongdoings as offenses against the state, okay. Against the state means which acts beyond the law, okay. So those are considered as offenses, okay, and not necessarily violating any private right and punishable by the state. Not necessarily violating any private right means it doesn't comes under the criminal law, it comes under the civil law. So that is why they have given like this, not necessarily violating any private right means it doesn't comes under criminal law but are punishable by the state, okay. So the criminal law means wrongdoings which are considered as offenses against the state law, the law which is enforced, okay, by the state. It determines that it is the wrongdoings as offenses. Okay, so those are criminal laws, and criminal law is a part of a public law. Okay, which is considered as unlawful act or else default act. Okay, and the society or the people are directly involved means, okay, those are directly involved under the unlawful act means, so it is considered as a criminal law. Okay, and their interests are represented by some governmental agencies. Officers will be there, officials whose obligation is to see that justice is accomplished and the ends of the society is fulfilled. Okay, so for in order to see this criminal law, okay, government agency will be there, officer will be there, officials has the obligation or else the responsibility to see the justice is accomplished. Okay, so finally, we can say that crimes are thought of as wrongs not only against the injured parties but also against the society also. Means criminal law means if at all any person who is injured regarding that criminal activity, not only that person is injured, okay, that party is injured, but also finally we can say that that unlawful act is against to society also. Okay, but generally in order to condemn those criminal laws, we have public servants like police. Okay, so they will prevent and detect the crime, they will prosecute the offenses. Okay, so coming to the civil law. Okay, so civil law on the other hand is primarily concerned with the rights and duties of individuals towards each other. So some examples of civil law are, as I said before, in the private law. Okay, here also the same aspect, civil law, under civil law. Okay, law of contract, law of property, law of tort, law of succession, family law, all these comes under the civil law. Those are not criminal laws. Okay, so in other words, what we can say means the term civil law refers to law dealing with the rights and duties of persons, okay, other than those created in the criminal law. In civil case, okay, the plaintiff institutes suit against the defendant for some civil wrong allegedly committed by the defendant. Okay, here plaintiff, defendant means nothing but the plaintiff is the person who is the victim or else who is the injured person, and the defendant is the person who have committed the mistake. Okay, so here who will have the right means the plaintiff has the right to sue against the defendant person. Okay, so this is about the civil law. Okay, the main object of the civil law, it is different from the criminal law. Okay, means in civil cases the object of the legal action begun by the private citizen is to establish the rights, okay, against another citizen or group of citizens. Okay, that is the case in civil case. Okay, and we can say that the main objective of the civil law is in general, okay, it is to restore the injured party or else the plaintiff to the position he occupied prior to the defense wrongful act. Okay, the plaintiff quite often seeks monetary damages in these cases. By the payment of damages, the plaintiff is deemed to be restored, okay, to his position before the wrongful act of the defendant. Whatever the position is held by the plaintiff before the wrongful act has done by the defendant, again to same position he will be restored by, okay, by getting monetary damages or else the damages from the defendant. Okay, and coming to substantive law and procedural law. Substantive law defines in regard to a specific subject the legal rights, obligations, relationships of people with other people or as between them and the state. Okay, between the people or between the people and the state. Okay, so that is the substantive law. It describes, it defines a specific subject like legal rights, the obligations, the relationships, how it would be. Okay, all these will be studied under the substantive law. Okay, basically their obligations, their rights, their duties, their relationships. Okay, for example, substantive law. What is substantive law means? For example, if we take a murder case, okay, so if at all there is a murder offense means under Indian Penal Code IPC, okay, it has defined there what to give judgment regarding a case, regarding a murder offense. Okay, so the IPC provides punishment for the crime. This is known as substantive law. Okay, so likewise, if we see any Indian Contract Act 1872, this is also a substantive in nature because a law has been created regarding the contracts. How should be contracts should be there. If at all there is any uh, um, thing happened beyond the Contract Act means, so what action should be taken, or else what is the punishment that is given according to the Contract Act. So substantive in nature means it defines, okay, it defines what is the punishment regarding to particular law, particular act. Okay, and coming to procedural law means it deals with the methods. Okay, the method and the means, the methods and means by which substantive law is made and administered. Okay, so we know that there is a substantive law. Okay, like as I said before, for murder offense, according to the IPC Act, there will be a punishment, IPC law. Likewise, for Contract Act also, there will be certain laws, certain punishments regarding that Contract Act. Okay, likewise, procedural law means how to what is the procedure to be followed to enact that law. Okay, for example, as I said before, in a murder offense, okay, so how the process should be, what is the method that should be followed in order to punish that particular person, or else in Contract Act, okay, what is the procedure that should be followed in any, for example, in negotiations, okay, there may be any against to law, there may be any negotiations. Okay, so how to deal with that Contract Act, what is the procedure, what is the method to be followed. Okay, so procedural law is nothing but how the substantive law is to be administered, what methods should be followed, okay, to this substantive law. Okay, it lays down the rules governing the manner in which a right is enforced under civil law, okay, or else criminal law. Okay, so thus provisions of substantive law define rights and duties, while procedural law provides the machinery for enforcing those rights and duties. Okay, so one is, it defines, substantive defines the rights and duties, and procedural defines the methods to be followed, or else machinery for enforcing those rights and duties. Okay, so that is about the substantive and procedural law. Okay, now coming to international law and municipal law. Okay, so international law is a set of generally accepted rules and regulations controlling the conduct of nations, international organizations and individuals. That is known as international law. So every country has their own rules and regulations. Okay, similarly, international law means nations have their conduct of rules. Okay, at the same time, international organizations will have, individuals will have. Okay, so international law means a set of generally accepted rules and regulations which controls the conduct of nations. At the same time, the international organizations and also the individuals who are residing in those nations. So that is international law. And coming to municipal law, it deals with the relationship between the individuals and organizations within a state. International law means it is accepted rules and regulations which is controlled on nations, on organizations and individuals. But coming to municipal law, it deals with the relationship between individuals and organizations with the state or else with country or else with nation. Okay, so while each state has its own municipal laws, the international law is common to all states and individuals. Okay, here international law is common to all other countries also. For example, if we have two countries, okay, US and India, there will be many aspects that will be done between these countries. So if we go for example, trade and commerce, okay, regarding the trade and commerce, both countries will have an international law, common international law for organizations, for individuals and for states also. Those have to follow according to those laws. Okay, so the International Court of Justice is charged with the responsibility of adjudicating the controversies arising under the international law or else between the nations. So who will see if any thing happen between the nations means International Court of Justice will be there. Okay, so that International Court of Justice is charged with responsibility of adjudicating the controversies arising between the nations. So that is about the international law and municipal law. So finally, what we can say means international law regulates relations among states. Okay, municipal governs the domestic aspects of the government and deals with the issues between individuals and between individuals and administrative apparatus. And municipal law is also known as national law or state law. Okay, so now coming to public international law and private international law. Public international law, it governs the relationships between the states, okay, international organizations and entities with global legal personalities. Okay, here international means not national, we go beyond the nation, means international. So international means different states will be involved, different organizations will be involved, so we are acting globally. So here global legal personalities and entities also will be involved. So that is a public international law, which means that it governs the relationships between the states, organizations and entities globally. Okay, global legal personalities. While coming to private international law, it is also known as conflicts of law. Okay, we can say that it navigates the intricate web of legal conflicts involving individuals and entities across diverse jurisdictions. Okay, means that here private international law, it is a type of legal service used when different sets of laws come into conflict on a specific matter. Okay, here we will see conflict in laws. Conflict in the laws means, okay, on a specific matter, different set of laws will be here seen. Okay, so it involves a set of rules that determine which legal system and which jurisdiction should be used to solve a particular disagreement. Okay, so if we see in past when India was under colonial rule, okay, we have various regions with different cultures and beliefs. Okay, and this sometimes led to conflicts between British laws and our personal laws in India. Okay, likewise, so during the time when India was a British colony, Indian merchants traded internationally and leading to cases of legal disputes that had an international aspect. And India followed many British rules about private international law because of its colonial status. Okay, so however, even after gaining independence also, India has struggled to create enough laws in the field of private international law. Okay, so we can say that public international law mainly focuses on the relationship between the countries, okay, international organizations and other entities, okay, that have legal standing in the international aspects. And it mainly deals with important matters like the use of force, diplomatic privileges, human rights, global trade, rights and responsibilities of countries, okay, so which they interact. So this is all about the public international law, what it focuses. But coming to this private international law, it handles the legal connections among private individuals, businesses, and other entities that do business across different countries. So it deals with issues such as acknowledging and enforcing judgments from foreign countries. Why? Because it is doing business with different countries. Okay, so many disagreements may appear in with other countries, with foreign countries. Okay, so in this case, which judgments should be followed? Foreign countries, or else choosing laws which applies and deciding which jurisdiction we have to follow, which jurisdiction is appropriate. So all these can be covered under private international law. Okay, so private international law relies on the laws of individual countries, international agreements, and principles of comity. Okay, so we can say basically public international law is mainly built upon treaties and established practices, and private international law is enforced through domestic courts and arbitration. Okay, and this public comes under the courts and tribunals. It is enforced through courts and tribunals, and sometimes economic actions and sanctions also can be seen in this public aspect. Okay, so this is about the branches or else classification of law or branches of law.